topicality overruling. Definition and interpretation overrule must be explicit. This impeachment in 1985, the court has shown that willingness to overrule the justice is recognized in inconsistent upholding textbooks loans without striking down the criminal loans. The decision upholding the textbook loan has never been overruled. Although this and similarities supported and validated by the court and the middle court, it is not overruling. The court merely adds new facts in consideration whether an overruling prior decision be the plan. The plan violates the average willing consistent with one of the decisions that is not cited by name. 3 is the reasons for forces granted a general precedent granted the middle example demonstrates precedent granted schemes the only true mechanism the topic is expanded across 4. This that court decisions. The second has limits implicit overrules will continue with the act for any case of decision to contradict any of the 30 plus holdings purpose key to education and fairness. The top category issue fairness and education. Next province led by Wilson DA. The plan undermined federalism causing war and genocide of Scalabrini 1995. The political branch cannot rely upon to enforce federalism. The court and acting 14th Amendment Congress law. It would be a good idea if the court continues to down the low path plan. That the political across the world is this global procrastination with an elimination of every federal federalism normally policy development and the great link with likelihood of future peace. We economic growth depends on a successful brilliance of nations to terrestrial islands whose rate that the framework can do its part in enforcing some every federalism low path could be the course of a net process and the impact are wasteful complex. It's the thing over to threat to humanity like in Marshall 1988 there are running more than 37 major international conflicts underway. 30 million people 30 million people displaced 7 million killed last night. We got without the greatest loss the greatest loss caused of human suffering may be facing an epidemic potentially and global government reports next time Supreme Court politics. In the uniqueness of court law being a liberal ruling metric for EPA at the top of the docket and will significantly reduce CO2 emissions at line. In 2 cases, the Supreme Court agreed to hear argument about the federal government must regulate property access for messages for EPA could break the global warming and conflict. The court will rule in the state's favor of the court and the ruling says the number 4 next year before the administration can have a profound impact on global warming lawsuits. The link was overruling Supreme Court decision to make Kennedy feel the court has changed its political capital report. In UK Court, the Kennedy 40 justices nominated the court of decision needs to get their justice appears willing to oppose it to review the political history in the institutions of Kennedy political behavior and traditional behavior that appears especially conservative protecting the court political capital. Many decisions are better understanding political conservatives the court political capital must be safer for the court to reprove the president while thinking the decision was wrong in the original manner to reveal to overturn a ruling or of a moderate action and overruling maintaining the decision may reach by prior court was that whether license part of the law for something overruling political law that did affect the court appeared to respond to the man. Second is Kennedy the perfect candidate for spillover press chances are not affecting negotiation. He in the Supreme Court is laying two cases Kennedy we're really got the side of the board and following the issues of the court facing Kennedy seems to be asserting himself more to be relishing the role Kennedy has been known to grow and has been known to broad oversubmission board in the middle of the case more than others. Kennedy seems conflict in the court case and his question of you negotiated and Kennedy seems to report of Massachusetts established 2 cases Kennedy run according to the opinion and the fellow between the government of full conservative for the burning most of the government's authority to protect rights and will be crucial on the greenhouse gas accord or likely make history by striking down Bush's chance against greenhouse gases and political capital steal the role environmental verdict draw equal and welcome to capital government to get 170 for the follow the equal of the law and to be climate cautious and non-cautious about one and allowing on the environmental system to say what the court has been called for to or the such cases are more from a use of rural fractions and processes environmental dispute mostly politically charged and sees the effects of liberal ruling key to court relations and they signal to state and international governments in New York Times and 286C court region that rule whether an EPA has the authority to greenhouse gas cases among the most important environmental disputes that come before the court versus heating and emissions are relatively responsible because we look at excited with the scourge the rest of the world from acting and the impact of runaway warming and extinction and within it to get a scientific understanding of the points of runaway warming mainly to extinction and gradually down and immediately put in place for to do further emissions of greenhouse gases out of the atmosphere. We're looking at the end of the extinction there are carbon rather could be releasing and the report on carbon and more important not gases to the atmosphere. Massachusetts is also vital to use EU to hide the polluters and UK 1 the United States has partly banned the treaty for the warming seen in the scene in Europe and Central United States EU relations to the EU global warming was an integral part of US-EU relations as the concern with the Bush administration stand and the relations that heat up preventing terrorism, biological attackers and house to gauge the strength of translated data they should be measured reports that the challenge research and posting out again Europe was the war here in the EU and the member states continue to grow there's also the EU countries agreed upon the sharing of law enforcement intelligence information upon the help of the United States to collaborate against terrorism and imperative of the job and it's not done because we do collaborate on vaccine for improvement and planning and how the international health community must come to biological weapons attack and the expected since September 1997 the one more likely to deliver hostile leads to their which would respond to data the directions of past and could eventually start from one victim to another would be capable of leading into the cascade of disease and model spreading the entire world. You relate that comes to the count plan. The United States Supreme Court should limit its decision United States v. Morrison to its fact by ruling that the Congress clause precedent established by the decision applies only to the civil rights remedy of the violence against women that the 50 state legislation relevant territorial actors should enact the legislation that includes motivated violence as a crime and recognizing the gender motivated violence as civil rights. That's the religion for promulgating a civil rights remedy and take force legislation should adopt a recommendation for animistic attitudes that informs what action as part of the one anti-violence legislation should make arrest in instances where the state of visual cause or gender motivated violence. The 50 state courts and relevant territorial actors should refer to the economic plan and the rule clarify the the Province is able to resolve the case limiting into effect as the state presidential effects of the overrules Benjamin and Canada court concluded that there was only with the laws of the bullet by the limited effect of overruling by the of earlier difference between such a ruling authorized but the difference could be lodged in a matter of fixing and the element of 100% of the act is a binary 2K2 it is a decision to deliver hours of a remedy constitution created and an opportunity for the legislature to have a technical to right that at the state level unanimous will offer an opportunity for the government to create an opportunity to transform an effective cause of action for very legitimate motive and valid and the action informing what action is key and your is responsible on the federal power remain you whose vision and establish the particular interpretation and the state level to provide an effective civil rights remedy that solves gender norms and inequalities minor 2K2 and which simply means that a different and a was motivated by gender non-gender such unanimous would allow you government to capture this in Congress and unconscious motivation when it on the nature of a harm must embrace anonymous right and that is informed one action and whoever to look at the organization from the over gender that would hold them to a legal play of zero tolerance and the benefit of state constitutionalism plan has a shadow over state constitutional interpretation and penalty for action and the only way to preserve to the show by the Ruins 1999 goals and 99 state court design make with the death of a controversial case the decision rejected Supreme Court recently and a result of that the problem rather than the Supreme Court out against the shadow for the state legislation and the board of otherwise would be a question of state constitutional interpretation shadow question we correctness and confidence in the global model of judicial federalism preventing civil war and the confidence of here in the China 1999 the new judicial ordinance is able to interpret the constitutional the state constitutional right provision and the new resident cancer protections and the federal constitution movement the model for other countries to follow American judicial federalism must be implications for merging their parties to revolution will rise the real interaction between race and our race and our economy matter of increasing conflict and such an arrangement could establish a right to speak without involving the nation into war and towards our parents. Judges. That of course all the cases taken into one state responsible domestic violence represents for that implementing gender violence state that is legislation having brought that aggressively legislation being pulling acknowledgement that it created a situation with the state legislation not afford to ignore the need for legislation that dealing with gender motivated violence the legislation across the country that every state has an active civil war around civil protection act such legislation for practically creating mandates in all 50 states and have an active domestic violence policy domestic violence or risk policies and policies are going to make it dramatic different and overruling motions not resulting in war and K2D, or as the the Congress Power Code 1391, and the Constitution to legislate Section 1391 enacted in 1994. Nobody even uses it as a media and Davis 2K1. And the Essex there were only 50 cases under the civil rights remedies. There were too many fewer cases than had been anticipated in the plan. The plan substitutes a symbol for substance insurance sensitivity to critical outcomes and fail to produce social justice for the program 2K6 without bar as a system to support for the change will not occur litigation substitutes a symbol for substance. The government litigation of schools is a permanent brown and change symbolic status gains celebrating symbol that influences self-satisfaction to the actual practices that brought a little more than an ornament where the system now produce social change and the defenders not to recall the world will see in 2K1 many if you want to be more work for justice and if you want to leave the sex industry before and work for justice specifically the court results in something that judges and justice cause what the evidence suggests causality want to police from the world was not a part of agenda or any other single cause rather than been a part of free was ascended after the name of justice so if you want to work for peace work for if you need you want to work for justice gender and others work for mediums and injustice and the main cause of what seems to be in fact inadequate the environment the Robert Court won't overrule ESA that the Robert American 2K5 the question of whether the ESA and 4K actions of Congress cause power the Robert Court intended to sustain in my opinion did not consider whether I was serving into common cause or other ways to sustain exactly we could look at those articulation of outside the scope of the common cause on the act of law or in the non-limited congressional authorities pickle in 2K3 the court started to use the question whether how whether the court has been in Congress has been alternative to this has been opposed to spending Congress has not seen a serious its own policy goal and has been true on any state powers including legislation to reform the Congress and not proceed their own powers have been diminished the court's position and I will not reduce the national policy or Iraq and who gave the training the United States environmental leadership and more than does not call the ESA to be struck down as slamming in 2K1 ESA will be held by the nuclear Congress was not authority to speech act with the problems of the treaty powers in Congress ESA that's straight to down not been implemented treaties ESA is valid of Congress and the treaty power.
Okay, when can you pick the counterclaim?
If you make permutations or theory arguments besides just what
okay. Let's talk about what the effect of limiting a decision to its facts is. Does that mean that in the world of the counterclaim, then the Morrison decision can never be applied again?
To anything besides the civil rights remedy and the law.
Let's talk about that question you were asking about in the cross-sex of the 1AC. Does the act of limiting Morrison to its facts overrule Lopez?
The act doesn't.
Okay. But how do you if your argument is true that other like all those justices will just continue to use the other precedent, how does
if that argument's true that leads to the plan?
No, well our argument is that the plan solves that because it sets a new
we still set a precedent. We read evidence as to why limiting to its facts still sets a theme form of precedent.
Okay.
You don't have to overrule Lopez and set that form of precedent.
Let's talk congressional signal arguments that are the internal
I mean,
link
we
to
still
for,
say- yeah.
for gender violence. Our internal linkage to our international human rights norms argument is that stripping Congress of its ability to legislate to solve international human rights
We will-
is
Yeah, our argument is
necessary.
twofold. First is we read a piece of symbolism evidence on case which answers all of your federal
That's
arguments.
hold on, wait. That symbolism argument is just about like the public. Where's the
No,
piece of
no,
evidence
that's
that you
not
read that talks about international symbolism?
I mean, our evidence indicates that it's not just specific to the public, that a form of symbolism is substituted.
It says litigation didn't give enough substance for the women's.
No, it indicates, that's not true. It indicates that if the world in which we focus on symbolism prevents any form of
And we'd argue that 50-state unity would lead to the same national symbol against gender violence as the
That's the answer that
plan
we
itself.
lead to congressional action on issues of gender violence, which are
I mean, we will argue
does not
that,
allow Congress to do.
we will argue that the 50 state legislatures can still act.
Do you have any evidence that says
I mean,
that
the bottom evidence-
hold on, our whole advantage is that giving it to the states was bad because it recused Congress of its
But that assumes a
obligation.
quo where the states haven't taken advantage of that authority. Our
No,
argument
it's
is
a question
twofold.
of
First,
jurisdiction. It's not about the outcome of gender. Okay, I have another question. Let's talk about this Reuter evidence that you tag as saying the Massachusetts case is key to U.S. EU tax. This is what this part says. The U.S. has effectively abandoned the 97 Kyoto Treaty to fight global warming, seen in Europe as central to U.S.-EU relations.
And then the next line of that part that I read, the next line of that part that I read indicates that global warming is central to United States
Yeah.
relations as seen by
Where's
the
the
EU.
evidence that says the EU perceives domestic, courts?
The United States would say that we can now regulate emissions, global warming emissions.
Okay.
How would that not be seen by the EU as an effort to reduce global
What
warming?
emissions does the Massachusetts case limit?
It allows
So
Congress and the
what
states to
is
make
that?
their own limitation. It
it
allows
would be like,
Do you have
directly it would be
evidence
automobile emissions.
Okay, do you have evidence that says that the EU wants the kind of regulations that the
Our evidence indicates
Massachusetts
they want
case would
limits on
result in?
global warming and they
Sure,
want.
but the fossil fuels topic was about how there are different ways to do that. Do you have any evidence that says they perceive that?
Our argument would be that we would lead to a Kyoto-style regulation of
Oh, yeah?
U.S. auto emissions.
Okay.